Good morning, everyone. I hope I am audible and visible to all of you. Okay, so let's start today's sessions. Good morning, everyone. Welcome back to our channel, Rostrum Legal. So today we are here on 31st of October 2024 in the class of Legal News Analysis, and today we are going to analyze the judgment of Supreme Court and different High Court. Okay, so let's start with the point number first. In the point number first, we are having the judgment related to the order. Basically, it's not a judgment; it's an order related to the IPR, intellectual property right. So in this case, what happened? The trademark and copyright infringement case was filed basically before the High Court by a very renowned company who is basically indulged in making the shoes, the Skechers. ठीक है ना? तो भाई स्केचर एक कंपनी है जिन्होंने एक इंटेलेक्चुअल प्रॉपर्टी राइट, कॉपीराइट इंफ्रिंजमेंट और ट्रेडमार्क इंफ्रिंजमेंट का केस फाइल किया था बिफोर द हाई कोर्ट। और उनका बोलना ये था कि साहब उनके जो कॉपी प्रोडक्ट्स है ना, चीप क्वालिटी प्रोडक्ट्स हैं, वो बेचे जा रहे हैं मार्केट में, जो उनकी लाइक जो रेपुटेशन है उसको वो एडवर्सली हार्म कर रहे हैं। गुड मॉर्निंग शैली, वेरी गुड मॉर्निंग, हैप्पी दिवाली शैली। Okay, so let's see. The Bombay High Court granted ex parte ad interim relief. Please, you need to understand what do you mean by the term. What is ex parte ad interim relief? Ex parte means one-sided, without hearing the opposite party. It is ex parte. What is ad interim relief? Firstly, you need to understand the interim relief. Interim relief should be considered as the relief given during the proceeding. But interim relief जो है वो विद इन 2 months प्रोवाइड किया जाता है, लेकिन जब उससे भी पहले चीजें प्रोवाइड करना मैंडेट हो जाए कोर्ट के लिए, दैट शुड बी कंसीडर्ड एज एड इंटरिम रिलीफ। मतलब इंटरिम रिलीफ से भी पहले कुछ प्रोटेक्शन दिया जाता है, दैट शुड बी कंसीडर्ड एज एड इंटरिम रिलीफ। तो इसका मतलब क्या हुआ कि भाई कोई भी ऐसा रिलीफ जो इंटरिम रिलीफ से पहले दिया जा रहा है विदाउट हियरिंग द ऑपोजिट पार्टी, दैट शुड बी कंसीडर्ड एज एक्स पार्टे एड इंटरिम रिलीफ। So, two global footwear brands, Skechers, South Asia Private Limited, in a case concerning LS trademark infringement by counterfeiters. Counterfeiters जो basically जो है कॉपी प्रोडक्ट जो है बेचते हैं, ठीक है। अब in the case Skechers South Asia Private Limited versus the Wardrobe and others. So a suit was filed before the High Court by the for infringement of trademark copyright in relation to the plaintiff's trademark. तो ये जो स्केचर्स ने ये पिटिशन फाइल किया बिफोर द हाई कोर्ट, और उनका बोलना ये था कि सर इट्स अ क्लियर केस ऑफ ट्रेडमार्क इंफ्रिंजमेंट, कॉपीराइट इंफ्रिंजमेंट। क्लियर है? सो स्केचर्स साउथ एशिया प्राइवेट लिमिटेड, अ लीडिंग फुटवेयर एंड अपैरल ब्रांड established in 1992, owns several trademarks including the well known name Skechers. They have so many trademarks. आपने देखा होगा एस लिखा रहता है, ठीक है ना, या एस पैटर्न में लिखा रहता है, उनके पास काफी सारे ट्रेडमार्क्स हैं। So they clearly said that sir, the shopkeepers in Indore and Indore and Nagpur, they basically try to like infringe their trademark. तो उनकी रेपुटेशन को वो हार्म कर रहे हैं क्योंकि वो चीप क्वालिटी प्रोडक्ट्स बेच रहे हैं इन द नेम ऑफ स्केचर्स। सो इन इट्स इंटरम एप्लीकेशन, स्केचर क्लेम दैट infringers by counterfeiting the product infringe their trademark and copyright concerning their artistic work. बोले they clearly said that it's we are dealing in a good quality product, but someone tried to taking benefit out of our name, our reputation, and trying to sell the cheap product. ठीक है ना? Not product not as per the mark. So they contended that these marks were uniquely tied to their product, which encompasses footwear, apparel, and accessories for all the ages. बोले साहब इनके नाम पर ये बेचा जा रहा है, ठीक है। बोले क्योंकि हम जो है स्पेसिफिकली हम बात करें तो फुटवेयर्स का एक अच्छा वेल नोन ब्रांड है, आप सबने सुना होगा स्केचर्स के बारे में। फर्दर दे आल्सो सेड दैट कि साहब हम हर तरीके के एज ग्रुप्स के साथ जो है डील करते हैं। So in October 2024, an investigator hired by Skechers discovered counterfeit goods bearing the company's trademark at the infringer's retail outlet in Nashik and Indore. तो भाई हुआ क्या कि सब जब ये information, when these type of information received by the Skechers, so they basically hired a investigator, a professional investigator, ठीक है ना, private investigator. They hired a person, and as per the report given by that person, that someone like some shopkeepers in Nashik and Indore try to like infringe your product. So these items were low quality imitations closely resembling genuine Skechers merchandise. तो बोले साहब आप जो स्केचर्स के जो प्रोडक्ट्स है ना उनसे बिल्कुल हूबहू मिलता हुआ प्रोडक्ट वो बेच रहे हैं और इससे रेपुटेशन स्केचर्स की हार्म हो रही है. So the plaintiffs provided photographic evidence and detailed description of the counterfeit products and highlighted their similarities to authentic Skechers goods. तो यहाँ पर स्केचर्स ने हाईकोर्ट के सामने, बॉम्बे हाईकोर्ट के सामने क्या किया है कि भाई उन्होंने बताया कि सर देखिए हमारे पास फोटो एविडेंस है कि इस टाइप के प्रोडक्ट बेचे जा रहे हैं तो उनको रोका जाए. ठीक है ना. अब कहीं ना कहीं क्योंकि ये ऑथेंटिक प्रोडक्ट से बिल्कुल रिजेंबल कर रहे हैं, ये बिल्कुल जो है एक डिसेप्टिवली सिमिलर प्रोडक्ट है. ठीक है ना, जो कि बहुत बेसिक रिक्वायरमेंट होता है किसका, trademark infringement का. So they clearly said that sir, it's a clear case of trademark infringement. We want the interim protection against such products जिससे कि भाई कुछ ऐसा irreparable loss ना हो जाए जिसको बाद में हम जो है रिकवर ना कर पाए. So the Bombay High Court, while allowing the interim relief, said that I am of the view that the adoption of plaintiff's trademark and the plaintiff's artistic work in relation to the impunged goods by the defendant is dishonest. They clearly said that the defendants are basically using the mark without having any permission from the sketchers, and they tried to extract benefit out of the reputation of the sketcher. That's why we are going to restrict that person from dealing with such type of deceptively similar products. So unless the relief sought for are granted, the plaintiff will suffer or are likely to suffer irreparable harm and loss and injury. So leading to granting of ad interim injunction. तो उन्होंने बोला कि साहब ad interim injunction देना मैंडेट हो गया है कहीं ना कहीं, क्योंकि अगर यहाँ पर हमने इनको नहीं दिया ad interim injunction या रिलीफ नहीं दिया, अभी स्टे ऑर्डर इंजंक्शन पास नहीं किया, तो फिर बहुत देर हो जाएगी और ऐसे लॉस हो जाएंगे फिर चीजों को मैनेज करना इम्पॉसिबल हो जाएगा. क्लियर है. सो जब भी आप इंटेलेक्चुअल प्रॉपर्टी राइट से रिलेटेड कोई भी मैटर देखते हो तो वहां पर एड इंटरिम रिलीफ बहुत जल्दी दिया जाता है. क्लियर हो रहा है. So this is the point number first. I hope this point is clear. So why I am discussing such points? Because I want you to give the clarity on the intellectual property rights matters. चलिए आगे बढ़ेंगे. In the point number second, we are having a very interesting judgment from the Kerala High Court, in which the Kerala High Court said that judges cannot be browbeaten with vague allegations of bias to suit a litigant's convenience. तो यहाँ पर इनका बोलना यह है कि साहब आप जो है ना जजेस को किसी भी तरीके से धमका नहीं सकते कि साहब आप जो है हम आपके अगेंस्ट में एलिगेशन ऑफ बायस लगा देंगे एक जज को. ठीक है ना, कि साहब लिटिगेंट ने क्या करा कि जज से बोल दिया कि आप देखो ऐसा है, आप ना बायस हो, आप ना एक तरफा झुक रहे हो और जो है हम जो है मतलब आप उनको एक तरीके से ओवरलैप करने की कोशिश करते हो. तो केरला हाईकोर्ट ने बोला कि भाई इस तरीके के जजेस को जो न्यायाधीश है उनको आप अफेक्ट नहीं कर सकते ये बताकर कि आप साहब बायस हो. क्लियर हो रहा है. सो इन द केस Naushad Flourish versus the name of the party is not given here. The petition was filed before the High Court by the petitioner seeking transfer of the cases pending in the said court, alleging bias of the presiding officer. एक transfer petition फाइल किया गया before the High Court. उनका बोलना ये था कि sir, I want to transfer my cases from this court to some other court because that presiding officer is clearly biased towards my wife. So the man had claimed that the presiding judge of Thalassery family court had shown favoritism towards his wife. तो उन्होंने बोला कि साहब जो प्रिसाइडिंग ऑफिसर है ना वो इनकी वाइफ का फेवर कर रहे हैं कहीं ना कहीं. दैट पर्सन इज नॉट न्यूट्रल. दैट्स व्हाई आई वांट टू ट्रांसफर माय केस फ्रॉम दिस कोर्ट टू सम अदर कोर्ट. क्लियर है. दीज आर द बेसिक कंटेंशन रेज्ड बाय द पिटिशनर बिफोर द हाई कोर्ट व्हाइल फाइलिंग द ट्रांसफर पिटिशन. क्लियर है. फर्दर ही alleged that the judge accepted the wife's petition without verification, issued ex parte orders in her favor. तो भैया इसका बोलना ये था कि जज ने विदाउट हैविंग एनी वेरिफिकेशन, विदाउट हैविंग एनी ऑथेंटिसिटी एक्सेप्टेड द वाइफ्स पिटिशन, वाइफ की पिटिशन को एक्सेप्ट किया और एक्स पार्टे ऑर्डर जो है इशू कर दिया. विदाउट हियरिंग द अपोजिट पार्टी इन्होंने एक्स पार्टे ऑर्डर जो है इशू कर दिया. फर्दर द जज dismissed the documents submitted by the petitioner as forged repeatedly, and when I am trying to submit the documents related to the case, then the judge tried to declare these documents as forged repeatedly. ठीक है ना, वो बार बार ये बोल रहा है अरे ये तो forged document है, हम नहीं करेंगे उसको एक्सेप्ट. मतलब वो कहीं ना कहीं वो मेरे अगेंस्ट में बात कर रहा है. that person is not neutral. So he added that the family court's consistent ruling in his wife's favor on matter like maintenance and custody suggests a clear bias against him. बोले साहब क्लियर कट में देखने को मिल रहा है कि मेंटेनेंस और कस्टडी के मैटर्स में उनका वन साइडेड डिसीजन देना इन फेवर ऑफ माय वाइफ that clear amounts to a situation of biasness. Clear? So the High Court observed that a judicial officer cannot be browbeaten to suit the convenience of a party to a list. तो इन्होंने बोला कि साहब एक पार्टी अपने अपने मतलब के लिए ना किसी भी जज पर इस टाइप के एलिगेशन नहीं लगा सकती, ठीक है ना। आप चीजें प्रूव नहीं करो फिर बोलोगे जज साहब बायस है, वो वाइफ की फेवर में जा रहा है। इफ वाइफ इज having the sufficient evidence to prove their case, then definitely the court is going to favor that party. It's a clear matter of it's a clear proceeding, ठीक है ना। अगर कोई पार्टी प्रूफ कर पा रही है तो डेफिनेटली कोर्ट उसके फेवर में जाएगी। That doesn't mean कि that person is that the judge is biased. Clear है? So unless allegation of bias against a judicial officer are sturdy and impregnable, courts cannot rely on mere apprehension to transfer cases from one court to another. बोले जब तक आपके पास sufficient evidence नहीं होगा that that person is biased, then definitely we are not going to allow the transfer of any case just on the basis of biasness, ठीक है ना। क्योंकि इससे होता क्या है, it is going to affect the reputation of that judge in a very adverse manner. Clear है? So in fact meritless allegation of bias against the judicial officer ought to be sternly and ruthlessly dealt with. Clear है? Further, the Kerala High Court, while rejecting the plea, तो plea को reject करते हुए क्या बोला, and impose the allegation of impose the cost of rupees 15,000, 15,000 रुपए का जुर्माना इनके ऊपर लगाते हुए क्या बोला कोर्ट ने, this court firmly believes that the transfer petition is a ploy to delay the proceeding and to prohibit the presiding officer from issuing order and various petitions. बोले साहब आप यहाँ पर ना डिले करने की कोशिश कर रहे हो, आप धमकाने की कोशिश कर रहे हो जजेस को, जुडिशियल ऑफिसर को, ठीक है ना, to delay the proceeding and prohibit the presiding officer from issuing order and various petitions pending consideration. तो बोले साहब जो मैटर पेंडिंग है ना उसमें आप क्या कर रहे हो, आप जज को परेशान कर रहे हो, उनको धमकाने की कोशिश कर रहे हो, डिले करने की कोशिश कर रहे हो अपने अपने मतलब के लिए. So such conduct has to be dealt with the iron hands and must be visited with cost. बोले साहब इन चीजों को अपना बहुत सख्त हाथों से लिया जाएगा और आपके ऊपर कॉस्ट भी इंपोज की जाएगी. तो कोर्ट ने यहाँ पर 15,000 रुपए की कॉस्ट भी इंपोज जो है की है. सो दिस इज आवर पॉइंट नंबर सेकंड. आई होप दिस पॉइंट इज क्लियर. ओके, मीनवाइल वीडियो अच्छा लग रहा है तो लाइक जरूर करिएगा. आगे बढ़ेंगे. In the case, in the point number third, we are having Delhi High Court judgment in which the Delhi High Court said that an accused in a money laundering case cannot be incarcerated forever by using the stringent condition for bail under Section 45 of the Prevention of Money Laundering Act as a shackle against him. So we have already covered such type of case in our last to last session. वहां पर भी जो Delhi High Court ने सेम चीज बोली थी कि साहब under Section 45 which clearly said that कि साहब bail cannot be granted under the Prevention of Money Laundering Act if the investigating agency having the sufficient amount of evidence, if enforcement act is having the sufficient amount of evidence, then bail cannot be granted in the matter related to the money laundering. Clear? So again Delhi High Court criticized this basic process. They clearly said that in the money laundering matter, you cannot incarcerate the person forever. You cannot use Section 45 as a shackle. आप उसको एक बेड़ियों की तरह इस्तेमाल नहीं कर सकते कि नहीं साहब आपको तो जो है बेल नहीं ही दी जाएगी. What happened in this case? Two bail applications were filed before the High Court by a couple, Vaibhav Jain and by two person, ठीक है, Vaibhav Jain and Ankush Jain. So basically, two petitions were filed before the High Court by the accused Ankush Jain and Vaibhav Jain in a money laundering case involving former Delhi Minister Satyendra Jain. हमने अभी सत्येंद्र जैन साहब का जो एक मनी लॉन्ड्रिंग का मैटर हुआ था ना, ठीक है ना, हम सबको पता है, उसमें ही ये इन्वॉल्व थे. अब सबको पता होगा सत्येंद्र जैन साहब को तो बेल मिल चुकी है. सो द आम आदमी पार्टी लीडर हिमसेल्फ हैड बीन ग्रांटेड बेल बाय द ट्रायल कोर्ट रिसेंटली. अभी उनको बेल मिली है. तो मेन एक्यूज को बेल मिल गई, तो भाई जो को एक्यूज है, जो रिलेटेड पर्सन है, उनको बेल क्यों नहीं मिलेगी? Following this, the co-accused had also sought parity, besides arguing that their fundamental right had been severely affected due to slow pace of trial. तो इन्होंने बोला कि साहब the Satyendra Jain साहब also granted bail in the matter जो कि main accused है. Further, इनका बोलना ये था कि साहब the delay in trial, the slow pace of trial adversely affecting their right to life with personal liberty defined under Article 21 of the Indian Constitution. इसलिए उनको जो है Article 21 के अंदर bail मिलनी चाहिए. These are their contention. So the High Court observed that when there is no possibility of trial being concluded in a reasonable time and accused is incarcerated for a long time, depending on the nature of the allegation, the condition under Section 45 of the Prevention of Money Laundering Act would have to give way to the constitutional mandate of Article 21. They clearly said that if in coming days, if the trial is not going to be commenced, then definitely in that matter, you cannot restrict any person's liberty on the name of Section 45 of the Prevention of Money Laundering Act. You cannot say that, sir, as per the provision of Section 45 of the Prevention of Money Laundering Act, so jail is the rule, bail is the exception. No, this is not going to prevail. So every person is having the Article 21 of the Indian Constitution. Every person is a right of speedy trial, and if the trial is not going to become as in the coming future, then definitely that person is eligible for the bail. That's what happened in this case. So the High Court said that as held in a catena of judgment like the Manoj Sisodia case, we have already covered this case, the constitutional courts have the power to grant bail on the ground of violation of Part 3rd of the Indian Constitution. So they clearly said that if in any matter, if it looked like that the Article 21 of any person is going to be infringed, then definitely the constitutional court is having the responsibility to protect their fundamental right by providing sufficient remedy. So as what remedy is justified in this case? Bail. So the sacrosanct right to liberty and face trial is to be protected even in cases of stringent provisions present in special legislation. So they said that it doesn't matter whether we are talking about the Narcotic Drugs and Psychotropic Substances Act, which is the NDPS, whether we are talking about the Protection of Children from Sexual Offences Act, whether we are talking about the Juvenile Justice Act, whether we are talking about the Prevention of Money Laundering Act. It doesn't matter whether we are talking about the special legislation or the common law. But the thing which prevail that in case the Article 21 is going to be affected, then definitely the Constitutional Court is having the duty to protect their right and provide the proper remedy. So the Delhi High Court, while granting bail to both the accused, the Vaibhav Jain and the accused Jain, they said that in a situation such as the present case, where there are multiple accused persons, thousands of pages of evidence to assess, scores of witness to be examined, and the trial is not expected to end anytime. They said that after observing the situation of this case, in this case, so where there are multiple accused persons, the court is going to so many thousands of pages of evidence. They are going to it should take time to access all the evidence. They have n number of witnesses the court need to examine. So as per the situation of the case, this case, we are in a clear cut mindset. We are having the clarity on that the trial is not going to be commenced in the coming future. So they clearly said that, and the trial is not expected to end anytime in the near future, and delay is not attributed to the accused. Keeping the accused in the custody by using Section 45 of PMLA is a tool for incarceration, and as a shackle is not permissible. So they clearly said that we are not going to allow you to restrain any person's liberty by using the Section 45 of the Prevention of Money Laundering Act. So this is the point number 3rd. I hope this point is clear. So if any person is having any doubt related to these points or any other point, any other topic related to any subject of law, please let me know in the comment section. Okay, so let's move further. Let's jump on the point number 4. In the point number 4, we are having Madras High Court's judgment, in which the Madras High Court said that High Courts are not empowered to condone a delay in filing appeals under the National Investigating Agencies Act beyond the permissible limit. So what happened in this case? Let's see. So in the Union of India and another versus Abdul Razak and another. So यहाँ पर हुआ क्या था कि point number 4. In the point number 4, Madras High Court said that कि साहब High Courts are empowered, ठीक है ना, to basically condone the delay within the limitation period given under the National Investigating Agencies Act. क्लियर है? तो इनका बोलना ये है कि साहब जो यहाँ पर टाइम दिया गया आप उतने ही टाइम पीरियड उसके ही लिमिटेशन के अंदर कंडोन कर सकते हो. कंडोन का मतलब होता है, कॉन्डोनेशन ऑफ डिले का मतलब क्या होता है कि भाई अगर कहीं पर लिमिटेशन पीरियड निकल गया है तो उसके बाद भी कुछ एक्स्ट्रा पीरियड होता है जहां पर कोर्ट इज हैविंग द पावर टू कंडोन द डिले. कि हाँ ठीक है, ओके, वी आर गोइंग टू एक्सेप्ट योर एप्लीकेशन, वी कैन गोइंग टू एंटरटेन योर केस, ठीक है, इवन आफ्टर द लैप्स ऑफ लिमिटेशन पीरियड. that process should be considered as condonation of delay. क्लियर है? तो भैया मद्रास हाई कोर्ट ने बोला है कि देयर आर सम रिस्ट्रिक्शंस इवन ऑन द कंसीडरेशन ऑफ कॉन्डोनेशन ऑफ डिले एप्लीकेशन. ठीक है ना? तो हाई कोर्ट उसके बाद न जाकर नहीं करेंगे वो चीजें. अगर कोई चीज लिखी है कि आफ्टर द एक्सपायरी ऑफ 90 days no court is having the power to entertain such type of cases, then definitely they have to follow these limitations. So what happened in this case? Let's see. In the case Union of India and another versus Abdul Razak. So NIA filed, a National Investigating Agency filed a petition before the High Court to condone a delay in filing appeals against the special court decision to grant bail to two accused. So basically what happened, the special court as the matter was investigated by the National Investigating Agency, the matter should be heard by the special court only. So special court granted bail to two of the accused. So against which the NIA is going to file the appeal. ठीक है ना? They are going to challenge. They are basically challenging the decision. But the limitation period was already expired. अब ये limitation period हो चुका है खत्म. ठीक है? So as related case was criticized by the High Court, Kitchen Bohari versus State, in which it was held that benefit of condonation of delay was extended only to the accused in National Investigating Agency's cases. So what happened in this case? So basically, a case was referred, the Kitchen Bohari versus State, in which it was held that कि भैया जो benefit है condonation of delay का वो केवल accused को दिया जाएगा if the application was filed before the court by the accused only. कि भैया अगर accused ने condonation of delay का application file किया है तो ही उसको benefit दिया जाएगा. If the application was filed by the prosecution, then definitely we are not going to help in that. So these words, in other words, if delay in filing an appeal was by accused person, the court had said that the same should be condoned. तो इन्होंने बोला कि साहब कि यहां पर अगर accused जो है condonation of delay का application file करेगा तभी उसकी help किया जाएगा. Prosecution के मैटर में ऐसा नहीं होगा. However, if the appeal was filed by the prosecution with delay, the same was to be dismissed on the ground of delay. Clear है? तो ये जो judgment था इसको कोर्ट ने क्रिटिसाइज किया. Further, NIA के जो काउंसिल थे उनका बोलना ये था कि सर दिस इज नॉट जस्टिफाइड कि साहब जब अक्यूज ही कॉन्डोनेशन ऑफ डिले का एप्लीकेशन फाइल करेगा तभी हम उसको एंटरटेन करेंगे, लेकिन अगर किसी भी तरीके से प्रोसिक्यूशन ने ये एप्लीकेशन फाइल कर दिया देन वी आर नॉट गोइंग टू एंटरटेन दिस एप्लीकेशन. क्लियर है? सो NIA काउंसिल आर्ग्यूड दैट सर दिस वाज अ डिस्क्रिमिनेटरी अप्रोच that would result in serious consequences and cause prejudice to the state's interest. तो इन्होंने बोला कि सर if these things going to happen, then definitely it was adversely affect the basic right, the basic working of the court. The NIA contended that if a delay is to be condoned at all, then the benefit should be extended to the prosecution as well as and not just the accused. They said that the condonation of delay application can be submitted by both the parties and it should be entertained by the court in both the matters. So this is what the correct way to treat the application under the condonation of delay. So the High Court explained that in absence of challenging the constitutional validity of any provision of an enactment, courts cannot read down the provision differently than that of the language employed in the particular provision. So High Court clarified that what is written under the National Investigating Agencies Act by dealing with the matter of condonation of delay, it is very much clear that we need to follow the exact wording unless and until that the wording is going to be ambiguous or confusing. If the things are quite clear, quite straightforward, then definitely we don't have any power to use the interpretation in that matter. Clear? So courts are expected to read the provision as it is and on the intention of the legislature. Section 21 subclause 5 the Negotiable Instrument Act, it's not Negotiable Instrument Act, it's a National Investigating Agencies Act, is unambiguous and intention of the parliament is so explicit. They clearly said that what is written under the National Investigating Agencies Act under section 21 subclause 5, it is very much clear that the things are unambiguous and the intention are very pure and clear. So there is no further scope to expand the interpretation in the matter of preferring an appeal and to condone the delay under section 21 subclause 5. तो इनका क्लियर बोलना ये है कि साहब जब सीधे लिखी हुई हैं तो हमें उसमें इंटरप्रिटेशन नहीं लगाना है. ये बहुत क्लियर कट है साहब. ठीक है ना? अगर कोई कंफ्यूजन बनता है तब इंटरप्रिटेशन ऑफ स्टैट्यूट्स वहां पर आता है. देन कोर्ट कैन एक्सरसाइज देयर पावर अंडर द इंटरप्रिटेशन ऑफ स्टैट्यूट्स. अदरवाइज दे डोंट हैव पावर टू यूज their interpretation to interpret the language given under the act. Things are quite straightforward, तो हमें यहाँ पर कोई भी interpretation नहीं लगाना है. The Madras High Court, while rejecting the plea, said that we hold that the High Court is not empowered to condone the delay beyond the permissible limit contemplated under section 21 subclause 5 of the National Investigation Agencies Act of 2008. तो Madras High Court ने बोला है कि साहब as the language used under section 21 subclause 5 is very much straightforward and clear, then we are not supposed to use the interpretation clause, interpretation power of interpretation in this particular matter. So consequently, the criminal appeal on the hand stand dismissed on the ground of limitation. So this is our point number 4. If any person is having any doubt, please let me know in the comment section. Okay, so let's jump on the point number 5. In the point number 5, they are having the Bombay High Court's judgment, in which the Bombay High Court said that the provisions of Maharashtra Educational Institutions Management Act of 1976 do not apply to religious and linguistic minority institutions. They clearly said that the Minority Educational Institutions Act are basically don't have any power to work on the minority institution, specifically the linguistic minority institution. अब linguistic minority institutions क्या होते हैं? The minority institution which are basically given the status of minority on the basis of language. भाषा के आधार पर दिए गए जो माइनॉरिटी का जो स्टेटस है वो लैंग्वेज के आधार पर, भाषा के आधार पर दिया गया. अब क्यों ये बात बोली देखते हैं. In the case Karachi Education Society versus State of Maharashtra and others, a petition was filed before the High Court by the Karachi Education Society, a registered public trust representing the Sindhi linguistic minority. So basically, they are using the minority status was given to that particular institution on the basis of language Sindhi. ठीक है ना, वो सिंधी लैंग्वेज को यूज करते हैं इसलिए उनको माइनॉरिटी का स्टेटस दिया गया. ठीक है ना. सो दे बेसिकली चैलेंज एन ऑर्डर डेटेड 21st of August 2024 बाय द डायरेक्टर ऑफ एजुकेशन पुणे. तो एक डायरेक्टर ऑफ एजुकेशन जो है पुणे के, उन्होंने एक नोटिफिकेशन इशू कर दिया था अगेंस्ट द लिंग्विस्टिक माइनॉरिटी बेस्ड इंस्टीट्यूशन. तो दैट वाज चैलेंज बिफोर द बॉम्बे हाई कोर्ट. So this order had appointed an administrator to oversee the society's school, Naveen Hind BT Shahane High School and Junior College located in Pune. तो यहाँ पर हुआ क्या था कि जो इस सोसाइटी के अंदर एक स्कूल रजिस्टर्ड है, that is basically considered as the linguistic minority institution, उसके ऊपर एक एडमिनिस्ट्रेटर को इन्होंने बैठा दिया और उन्होंने बोला साहब इस जो एडमिनिस्ट्रेटर है ना वो आपकी वर्किंग को जो है ओवरलुक करेगा. क्लियर है. सो दैट वाज बेसिकली चैलेंज कि सर इस टाइप से एडमिनिस्ट्रेटर अपॉइंट नहीं किए जा सकते. ठीक है ना, स्पेशली फॉर द लिंग्विस्टिक माइनॉरिटी बेस्ड इंस्टीट्यूशंस. सो द पिटिशनर आर्ग्यूड दैट as recognized as the linguistic minority institution, the provision of the act should not apply to it. इन्होंने बोला कि साहब क्योंकि हम minority जो है linguistic minority institution है, so that condition is not going to be applicable on us. They clearly said that they cited a certificate from Minority Development Division affirming their status, thereby asserting that director's order was beyond jurisdiction. तो इन्होंने बोला कि साहब कि जो डायरेक्टर्स के ऑर्डर हैं, they are not applicable on us as we are the minority linguistic based institutions. Further, the High Court said that the provisions of Maharashtra Education Institution Act of 1976 could not be invoked against institutions run by linguistic minority. तो हाई कोर्ट ने भी ये चीज मानी कि सो महाराष्ट्र एजुकेशन इंस्टीट्यूशन एक्ट है वो लिंग्विस्टिक माइनॉरिटी बेस्ड इंस्टीट्यूशन पर एप्लीकेबल नहीं होगा. क्लियर कट. This exemption is explicitly outlined in section 12 of the act, which clarifies that the law does not apply to educational institutions administered by the religious or linguistic minority. तो इन्होंने बोला कि साहब ये किसी भी तरीके से किसी भी एजुकेशनल इंस्टीट्यूशंस पर एप्लीकेबल नहीं होगा अगर वो रिलीजियस या लिंग्विस्टिक बेस पर माइनॉरिटी दिया गया. So finally, the Bombay High Court, while allowing the petition, effectively reinstating the management authority of Karachi Educational Society over its school. तो इन्होंने क्या बोला कि साहब यहाँ पर जो आपने इस पिटिशन को अलाउ करते हुए इन्होंने ये चीज बोली कि साहब जो मैनेजमेंट अथॉरिटी है ना कराची एजुकेशन सोसाइटी की, वही केवल डील करेगी. द डायरेक्टर ऑफ एजुकेशन हैव नो राइट टू अपॉइंट एनी पर्सन टू ओवरसी द वर्किंग ऑफ एनी इंस्टीट्यूशन रजिस्टर्ड अंडर द सोसाइटी बेस्ड ऑन द लिंग्विस्टिक माइनॉरिटी इंस्टीट्यूशन. क्लियर हो रहा है. सो दे क्लियरली सेड दैट कि आप अपने मैनेजमेंट को एस्टैब्लिश करिए, रीइंस्टेट करिए और वही चीजें जो है देखेंगे. सो हाउएवर द हाई कोर्ट क्लैरिफाइड दैट स्टेट कुड परस्यू लॉफुल एक्शन अगेंस्ट इंस्टीट्यूशन इफ वारंटेड. लेकिन उन्होंने दिया कि स्टेट गवर्नमेंट हैज हैविंग द पावर टू डील विद द मैटर, डील विद द इंस्टीट्यूशन इफ इन केस ऑफ एनी if anything happened beyond the permissible limit, if anything goes against the government, then definitely they have the power to deal with them. But in this situation वो यहाँ पर जो डायरेक्टर ऑफ एजुकेशन है वो यहाँ पर डील नहीं कर सकते क्योंकि लिंग्विस्टिक बेस्ड माइनॉरिटी इंस्टीट्यूशन. Okay, so we are done with today's session, guys. I hope you enjoyed the session. Thank you so much for attending this session. My name is Varun Saxena, and today we covered the legal news analysis session for 31st of October 2024. If any person is having any doubt with these points, please let me know in the comment section. And happy Diwali to all of you. And दिवाली को अच्छे से सेफली जो है सेलिब्रेट करें, लॉफुल तरीके से सेलिब्रेट करें, जैसा आपका मन करे. बस सेफ रहें, दूसरों को सेफ रखें. बाकी त्योहार साल में एक बार पड़ता है. खुश रहें और जो है दूसरों को भी खुश रखें. थैंक यू सो मच. सी यू ऑन डे आफ्टर टुमारो. कल हमारी क्लास नहीं होगी, ठीक है ना. हम मंडे को मिलेंगे, मंडे बोल रहा हूँ, डे आफ्टर टुमारो मिलेंगे. इन केस किसी को कंफ्यूजन होता है डिस्कस जरूर. थैंक यू सो मच.